Good afternoon, everybody. My name's Stephen Simblett. I'm chairing this event this evening. I see we've got at least 89 people involved in this on this sunny afternoon. So thanks very much for attending and sitting in a darkened room to listen to the talks that are being delivered. We've got an excellent and expert panel who are going to talk you through various discrete cases within the last year or so that they think are important and that they can say something useful about to help you all with your different practices and different concerns and so on. I'm going to leave it to each of the panelists to sort of outline what they're going to talk about at the start of their talk. But we're going to, and there will be a space for questions and answers. Since everyone's attending on Zoom, as you can see, there is a Q&A, and there's also a chat. In relation to questions, it makes sense to put those in the Q&A because that's what it's for. I've already seen something in the chat, which is, will you be able to get a copy of the recording afterwards from Pia? Yes, you will, because it's being recorded. So everyone who is taking part in this has consented to be recorded, and the recording will be available from Garden Court and sent to delegates and so on. So yes, Pia can have that, and so can anyone else. I think that's probably it. I'm a member of the public law team and the civil liberties team in Garden Court. So in a sense, I have a general interest in this area, and one of the things that Chambers has recently begun a project on is setting up a project on school exclusions, an important topic, some of which may be alluded to in the talks that we're going to hear. But as I've said, the speakers themselves are picking out particular key cases that they want to illuminate us about in their talks. And I think we're going to begin first with Ollie. So I'm going to mute myself and hand over to him. Take it away, Ollie.
Thank you, Stephen, and thank you everyone for joining us on what is a very sunny afternoon. And we are going to try and go pronto so that you're allowed to go out and enjoy the sun. I will be primarily speaking to the issue of specificity, which is a perennial issue that has recently had some clarity in the upper tribunal's two significant decisions, which I'm going to go through. I would be really interested to see or read in the chat box even, what various different people who are in the audience, their experience of the tribunal has been since the first tier tribunal has been since these upper tribunal cases, and whether there are any practical tips that they've discerned from the issue of specificity that they would like to share with the audience more generally. But I will briefly walk us through the case law. So the first case, and it is almost exactly a year ago that this was handed down, is Worcestershire County Council against SE. The facts of this case are not especially important. It was a BFI appeal, and various amendments were made to each of those sections. And I just wanted to note that the 11 principles that were the judge distilled down, well, they sort of 11 bullet points that the judge distilled down, which was an attempt to survey the case law on the issue of specificity and to provide some clarity. The judgment extends to 77 pages and is well worth a read in full, as it is essentially a textbook chapter on the case law on this issue, with at paragraph 74, the judge trying to identify exactly the key points that have emerged from this case law over time, with a view to providing clarity to people bringing appeals in the first tier tribunal, and indeed judges determining appeals in the first tier tribunal. So no surprises that the starting point is Clark and Somerset. In relation to any particular statement is whether it is so specific and so clear as to leave no room for doubt as to what has been decided is necessary in the individual case. Very often, a specification of hours per week will no doubt be necessary, and there will be a need for that to be done. So that's Clark, that's the starting point, and what the judge in Redbridge described as the high watermark, which perhaps has been resiled from slightly by the time we get to the end of these 11 bullet points. So the second bullet point is this is a context-sensitive exercise, and the judge was very clear to put language that caveated that this was an absolute duty. For example, very often a specification of hours per week is not always a specification of hours per week. So lack of particularity may allow less specific provision. A more detailed case may require more detailed provision. That is essentially a common sense principle that the more complex the case, the more detailed provision might be required. As I said, quantification in hours not always required. Not all details need to be specified. It does not have to be an entire treatise on a very granular level, setting out what is needed. Failure to specify a level of support after a particular date, potentially unlawful. So that is a kind of situation where it says up until end of June and then reviewed thereafter. That is potentially unlawful and was made clear. But that was already well established in the case law beforehand, but distilling the key principles, look to paragraph 74 of Worcestershire, you can find it there. Anything framed in terms of recommendations is likely to offend the principle of specificity. We want requirements, not recommendations. Otherwise, it's vague and unenforceable. The tribunal is an expert body, is the next point. It can determine issues itself. It can't go off on a frolic, as the case law has said, and make non-evidence-based conclusions. But it is for the tribunal to decide what is an appropriate level of flexibility, and because of its expertise in this area. And I know most people here will be very familiar with how the tribunal works, but there is at least one lay member who has substantial expertise in special educational needs and disability issues, but not a lawyer. And quite often their views will be given substantial weight when determining what level of how flexible it is, because they've got the real world experience as well of seeing these plans work in practice. The plan is not just for the moment it is made, but for the future. And that needs to be remembered. And the judge is very clear that actually there's a trade-off between absolute precision, which requires continual revision, because a child's needs change and the provision that's suitable for those needs changes. And if you're going to have it on a very granular level, fixed to a specific point of time in the child's development, then actually you're going to have to revise this, the process of which is very disruptive in itself. And the judge was clear, professionals do need to have some room for maneuver to trust their own judgment. It can't be so prescriptive that it means that professionals have no input in interpretation of this. Then we get to the 10th bullet point, and as you can see, we're slightly moving further away from the first bullet point, which was Clark, and it has to be a realistic and practical document. And that's absolutely right, isn't it? You want the EHCP to be understood by whoever's picking it up in the school, local authority, whoever the parent. It needs to be realistic, practical, understandable, so that it is enforceable. More flexibility where provision is for a special school. Well, that's quite an important and actually discrete point that can be relied upon in appeals when arguing about specification, is that actually special schools have expertise and there is specialist provision that's built into those special schools. So actually going into a granular level about the level of specification is less required there than, say, a mainstream school, which might be less familiar or not automatically providing the sort of specialist support. So they need to have their hands held a little bit more in terms of understanding how to implement an EHCP. So this case was followed on by Redbridge, and the facts of that case were actually a little bit more significant in terms of understanding how to apply the criteria. But I'll briefly go through the principles that the judge emphasised in addition to adopting the analysis of the judge in Worcestershire. So look, starting point, statutory duties of the local authority. The plan must give them a clear picture of what it is required to provide. And that was fairly self-evident from Worcestershire, but it's good to have it spelt out. It's a freestanding document, so you're not meant to be using it alongside expert reports, which I actually had argued, the other side argued in a recent EHCP appeal that I did, which was, oh, we don't need that level of detail. The school can just look at the expert reports. No, that's not good enough. Flexibility should not be used as an excuse for a lack of specificity. Essentially, this is a reasonableness test. Like, what is a reasonable level of specificity? And how the overarching question that judge was asking, how specific is enough is enough. If you could reasonably provide the detail, then you should provide it. That you need flexibility. That flexibility is in itself a good thing, is not justification. So where the next point I think is quite interesting, the nature of provision, and that actually experts will know, experts giving evidence to a tribunal will have an understanding of what's workable because they have expertise in this area. So we all see expert reports that say 10 hours, etc., of SALT, etc. Look at nature provision. The expert will have an understanding of what is needed to work. If they've set out a sort of template wording, then my impression is that the tribunal is saying weight should be given to that because they understand the issues in play. And then I think perhaps the most helpful part of the guidance in terms of people preparing working documents so that they don't offend the principle of specificity is actually what are the words that are likely to be problematic and unenforceable, because the overarching messages of like, oh, it's case by case, context sensitive, etc., perhaps doesn't give the practical guidance that solicitors, legal advisors, and your families and local authorities trying to draft EHCPs need. And so some of the words such as support, input, interventions, and opportunities, the much hated word opportunities, when unadorned by specifics, are unlikely to be sufficient. So the specific wording that was ultimately blue lined in the London Borough of Redbridge case is a trusted and familiar psychologist. While the terms trusted and familiar seem to be retrofitting, the tribunal says, to a specific person. It also created a Hobson's choice that specific person had to be named. Trusted and familiar could, so essentially, that was unenforceable if that one person wasn't available. So that was considered to be to impugn the principle of specificity. Moving on to LB and DJ against West Sussex County Council. This isn't a published decision, but very kindly shared with me by Eleanor Writer, SOS Sen. And I just wanted to highlight a couple of interesting points that arise from this. One in relation to specificity, but one in relation to procedural fairness more generally, which is a reminder of basic principles, but nevertheless a useful one. So taking specificity first, the judge at the end was giving some hints on when the decision was going to be remitted about the approach that should be taken to specificity. Again, opportunities appeared as an offensive word that there was a strong steer that the tribunal would want to look again at. Educational staff, school staff, and other professionals not clear enough, and appellants should identify all points of dispute, although tribunal has a duty to identify and correct areas of the working document. So actually, a tribunal can look at areas where there actually has been agreement, and a tribunal should be looking for, even though it's in normal font in the working document, if there are howlers like opportunities or other terms that are unenforceable, particularly, and I think particularly they should be doing this when a party is unrepresented. And we all know the barriers to legal aid and access to justice in this area in the first tier tribunal, and that is very much the topic of another webinar. But they do have the independent duty to look at provision that hasn't been underlined, etc., or struck out. Where there is disagreement, where it's undisturbed, they can look at it, and you can raise that on appeal. But this going to the procedural fairness point, which was in dispute here, the tribunal, this happened before COVID, and it concerned telephone evidence being given by an OT. And the facts are not necessarily that important, but essentially the line of the person giving evidence, the telephone line, was very disrupted and very poor quality. And it also seemed to interrupt another witness giving evidence. The combination of the two meant that there was not effective participation of at least one of the witnesses and potentially both. And actually key issues that could have been addressed by the witness with the poor telephone line in particular were evidence was not taken, and actually the tribunal probably fell into error as a result of that procedural failing. So the key point to take away from this is that everyone has to be able to participate in proceedings effectively. And I think you need to be very clear on that in your head when, if there are technical issues in, we all know that on the Send Tribunal is now all online. If there are issues with your witness not being able to hear properly, etc., frustrating as it is, everyone needs to participate. I found judges very sensitive to this issue, but if not, it's absolutely crucial that everyone is able to participate effectively, and regardless of what reasonable adjustments they need to be made, effective participation is core to the principle of natural justice. So I very briefly and more than anything wanted to flag that substantive, interesting and hopefully helpful decision is going to be handed down shortly by the High Court in a case against Devon County Council. The procedural history of this judicial review is somewhat complex. It was heard, it was found to be academic, went up to the Court of Appeal, has now been remitted, and we're expecting judgment any day, or maybe that's putting it too highly, soon. And it concerned delay in amending an EHCP after following a review. And a really important, interesting issue. I'm not going to go into the substance of the issues that are the substantive issues, the issue of statutory construction that the High Court will be grappling with in its upcoming judgment, because this was about academic claims. Essentially, the judge at first instance heard substantive issues and also heard submissions on academic, whether the case was academic, and then decided it solely on the basis that it was academic, and didn't give an indication about how to approach the issues of statutory construction that have been brought. Now, this was despite Mrs. Justice Eadie finding it granting permission to apply for judicial review, and academic whether claims are academic being a classic permission filter, and her finding it not to be academic. And it was a reasoned decision that it wasn't. Therefore, the parties incurred the cost of preparing the hearing. respondent did not suggest in its skeleton argument to hearing that the construction issue should not be decided because it was academic. Not only were the parties ready to argue the point, they argued it fully. The judge accepted the construction point was a short point and it raised general issues of public interest, and had even given an indication that he would decide the issue or give his view. So a huge amount of time, money, etc. was spent. And then the dispute in this case was applying the Salem test about when to consider academic claims. So the judge sort of fudged the question, the Court of Appeal slightly fudged the question about whether it was an academic claim, and then proceeded on the basis, if it were, what was this the kind of opportunity when you should exercise the court's discretion to consider academic claims on the basis of it being an important issue. And I think paragraph 55 is potentially quite useful in other contexts where you're trying to bring judicial reviews around special educational needs issues. So the issue potentially affects many children and young people who have EHC plans and the local authorities which are responsible for maintaining those EHC plans. So what had happened in this case is essentially they'd decided that the issue of delay had gone away because by the time of the AOS, plans had been issued. But it was possible to arise in the future, and we all know with EHCP disputes that these are quite often long-running things and repetitive things happen again and again and again. It concerns a short period in a longer process, so it is unlikely ever to be live by the time an application for judicial review reaches a substantive hearing. This is often the case with quite a lot of delay JRs, often moot by the time of final hearing, because it's a point in a stage in a whole wider process. And that is very much the case with EHCPs, where there's a rolling process, as it were, with the EHCP cycle, with annual reviews being the sort of annual marker. Yes, and then, yes, basically, there were also no other points to go against here exercising the discretion, which is not what I've included. I haven't included that point in the slides, but I thought this was quite interesting because it showed actually EHCPs as a context are quite a useful, ripe one for the court to exercise its discretion to determine academic claims, and partly because it was a statutory construction issue, but partly because of all of the sort of wider public interest issues that relate to children with EHCPs that need to be determined. And that ends my slides, but I am playing the role of clicker for Gronya. So I will go on to the next slide, which is for Gronya.
Thank you very much. You're much more than a clicker, Ollie. Thank you.
Yeah, I was going to say fluffer. But anyway, thanks very much, Ollie. Gronya's slide is all in position, and the point since I'm just marshalling this here and there, the case that the points that Ollie made about the discretion to decide academic claims, that case is of importance generally in public law, not just in education law, and is actually quite a useful authority on the point. And the Salem decision, which Stephanie Harrison all those years ago was involved with, and as she rather wryly pointed out when we were discussing the case Ollie was on about, in Salem, the House of Lords decided not to hear an important immigration appeal because they thought it was academic, and years later, the refugees, as they then became, after languishing around for years and years, established the point that they would have established in Salem. So pushing for cases to be decided when a court says it's academic is something that you may well want to consider generally. Anyway, here we go. I'll shut up again and let's put Gronya's slides up.
Thank you, Stephen. Thank you, Ollie, and thank you all for joining us. I am very impressed. I hope at least some of you are listening to this in your garden. I am going to just touch on three different education cases. The first is a judicial review of BA, which we'll come to, and the second is an upper tribunal appeal from the SEND, first tier tribunal, and then finally just touching on an interesting Court of Protection case concerning the education of a young disabled adult. So starting firstly with BA, this was a judicial review challenge in the High Court, I think it was handed down a couple of weeks ago, and it was in front of His Honour Judge Coe QC, and it was about failure to provide provision specified in section F of an EHCP, and the family brought a challenge in relation to that, saying it was a breach of duty, the duty obviously being the mandatory duty in section 42 of the Children and Families Act. And I think many of you, I know certainly we've seen quite a number of these section 42 challenges, in particular during the pandemic. So I've chosen it because I think it's interesting, not only on the weight, if any, to be placed on external factors like a pandemic or funding issues in local authorities, etc., but also because of how the judge deals with past breaches and the approach to remedy, because in this case, it's quite often argued there was no need to go to a court. We were going to resolve it ourselves. There was no need for a mandatory order. We were going to try to cooperate with the family, etc. So it's very interesting on those points in particular. But just on the facts, very compelling facts. A young boy who was 10 years old with really very severe special educational needs and a life expectancy only until his mid-teens, and his family had given quite compelling evidence about the importance to him of every day and every opportunity that he could get. There was an appeal to the first tier tribunal, and the family largely succeeded in that, but there were repeated delays in trying to get the provision in section F for a variety of reasons, and there were a number of successful complaints, including one upheld to the Ombudsman. So very strong facts. On the law, the judge really was very brief. There were no complicated legal arguments really, but the judge made it clear that the duty in section 42 is an absolute and non-delegable duty, that there is no best endeavours defence, because the local authority was saying, well, it was really quite hard. We had the pandemic, we were trying to do X, Y, and Z, and the judge was quite clear that it's a mandatory duty and that there is no justification. Another couple of arguments that were made, which were interesting, was that the local authority said we don't have to comply with an EHCP immediately, that the issue of reasonableness should be read into that. It's not forthwith or immediately. And also, as I've said, that there was no need for a mandatory order because the local authority could be trusted to work with the family. The family argued that matters being in train wasn't good enough, that they had been in train for some time, and that reasonableness wasn't a requirement, it was one of necessity in section 42. And they said that local authorities have 5 weeks from the date of the tribunal decision, in this case in relation to section F, to when the final plan has to be issued. And those 5 weeks should also include things like finding therapists and making practical steps to ensure that the provision is actually available to the child within the 5 week period. And the judge accepted that. And I think that's something that's very helpful to be able to rely on in other cases. So that really local authorities should be taking steps to ensure that the plan can be implemented within that 5 week period. The judge also said he didn't go into much in terms of findings as to how long was reasonable. But in this case, he said a year is not reasonable on any analysis. He accepted the 5 week submission. He was quite dismissive of the impact of the pandemic on local authorities, saying that in practice in this case, that wasn't what had held up some of the discrete issues of provision. And interestingly, he did hear arguments about whether a mandatory order was necessary, and he did grant one. So their family obtained both a declaration that there was an unlawful breach of section 42 and a mandatory order. And the mandatory order, the judge deals with in the final paragraphs, and he says, I'm going to make it, given the history of this matter. He took into account the past events, the excessive delay, and also what is in the child's interest, and in particular that impetus is not lost. And he felt that a mandatory order would assist with all of that. Also practical on remedy, because the judge said, and this might be something that would be useful to rely on in bringing a Section 42 challenge. 4 weeks was what he felt was appropriate for the majority of the provision in Section F, and 6 weeks for a particular chair for various reasons. So a very helpful judgment, which is, of course, as they all are, relevant or in terms of the individual facts, but very helpful on delay and on remedies, and hopefully will be of interest to some of you who are dealing with Section 42 cases. And I would be keen to hear from all of you later on as to your experiences in terms of delays, and if you've had a different experience from the courts to that of the family in front of Judge Coe. So that is the first case that I wanted to touch on. Ollie, self-appointed clicker, thank you very much. The second case is different, and this is an upper tribunal appeal. I think there have only been 3 or possibly 4 on the upper tribunal website this year. So this one, again, was partially allowed. 2 out of the 4 grounds which the family brought were allowed. And it was a Section B, F and I appeal. And it really deals with the approach to Section I in this case. And the child in question, it was an 8-year-old boy with a range of difficulties in speech and language therapy, fine, and gross motor skills. And he needed, it was accepted, a low arousal environment. And really this case is useful because the families were quite critical of how the first tier tribunal dealt with that evidence, and submitted that they had failed to engage properly with it, failed to give proper reasons, and the upper tribunal accepted that, largely on its facts, in that there was some evidence from the head teacher of the school that it probably wasn't a low arousal environment, and the upper tribunal felt that the first tier simply didn't really engage with that point, and said that the school would be able to make adjustments, but didn't specify what they were. And so it was altogether, in the upper tribunal's view, quite unsatisfactory. So helpful just in terms of framing appeals from the first tier tribunal, particularly reasons appeals or appeals about how the first tier have approached the evidence. And again, interesting on remedy, because it was a Section I appeal, and the boy had in fact gone to the primary school that the family were concerned was not suitable. But despite that, the upper tier remitted the whole case to a fresh first tier tribunal in order to consider matters afresh, I think with the acknowledgement that it may well involve a change of placement, or at least that was one potential outcome. So interesting on appeals generally, and on the approach to Section I and reasons and evidence in the first tier. So that's J, I and SP. Thank you, Ollie. My third and final one is very different. Again, this is a Court of Protection case of His Honour Judge Dodd, and it concerns capacity to make decisions as to education. And this was a 19-year-old man with autism and a learning disability. He hadn't been in school for 2 years, and the local authority brought a case to the Court of Protection for a determination as to whether he lacks capacity, both in relation to decisions under the Care Act, and also, interestingly, in relation to education. So there were 2 education limbs that the court considered. The first was, does this young man lack capacity to make to consent to an EHCP assessment? And secondly, whether or not he has capacity to make decisions more generally about his education. The court looked at what the relevant information would be for both of those tests. So for the EHC assessment, it was really quite simple in the court's view. The relevant pieces of information were simply what an EHC plan was, that other people would be consulted, that it would give him enforceable rights, and that it was only available up until 25. The court dismissed some other suggestions from the local authority and I think the official solicitor about further examples of what should be included in assessing capacity. And also in relation to making decisions as to education, the judge kept it quite simple: the type of provision, the type of qualifications, cohort of pupils that this young man would be with. That was all that was required. So there was no need in assessing capacity to discuss issues like, for example, the social impact or the social benefits of education, and that was the basis upon which the judge heard evidence and submissions and concluded that this young man did lack capacity. And in practical terms, what that meant was that the local authority had a duty under the Care Act to assess his needs, which could include, of course, his education needs, with a view to providing him with some education. So interesting overlap, crossover case there in the between education and the court of protection, and one for that reason that I thought it was interesting to flag. And I think that does conclude. They are my 3 cases. So thank you all very much. I can see some questions coming and we might deal with them at the end.
Yeah, thanks very much, Grania, and thanks very much, Ollie, the Clickmaster General. Are you staying in that post for Michael, or Michael? I think Michael's going to talk about issues in the I think this is issues in the. This is a more general sort of public sector equality duty and things like that, and how they arise in education law. So we'll move over to Michael now. Thanks very much, Grania, and we will start working on some of the questions in the Q&A as and when people can deal with them. So fire away, Michael.
Great, thanks very much, Stephen, and thanks again to everyone for joining us. I don't have a bells and whistles PowerPoint presentation for you, so I hope you'll forgive me for that. But what I wanted to do was take a brief canter through another Redbridge case. Experienced practitioners will not be unfamiliar with Redbridge coming up in the context of special educational needs related cases. And this is the decision of the Court of Appeal in a case of ZK, which was heard at the back end of last year, I think on the 1st of December. And raises a number of interesting questions. One is about the approach to systemic challenges by reference to the mandatory nature of Section 42, right? So the root of this challenge really in this case was that the way in which decentralized provision of special needs was catered for, it was argued, was inherently incompatible with the mandatory nature of Section 42, and for that reason, unlawful. And I'll come on to set out the facts in a bit more detail shortly. But it also touches on a couple of other issues because there were some particular factual challenges to the decision of Mr. Justice Swift at first instance. But there were also 2 other grounds of challenge that related to disability discrimination, and also the approach, as Stephen was indicating just a moment ago, to assessing compliance with the public sector equality duty. So just to give you some of the facts, the lead judgment was given by Lady Justice Simler and actually is set out in a very helpful way. And the essence of ZK's challenge was that Redbridge, like many local authorities, you have to forgive me for any hay fever related interruptions. Redbridge, like many local authorities, had adopted what was described as a decentralized model of special educational needs support. In other words, where a child was in need of special educational needs provision, it was arranged and facilitated effectively at local level at individual schools. And in ZK's particular case, the claim was brought on her behalf by her mother as her litigation friend. So ZK was blind as a result of having suffered a brain tumour, and she had an established need for a particular form of Braille, and therefore needed an assistant who had proper training in the relevant Braille, and it was centralised UBV Braille training, at least at level 1 and then eventually at level 2. And effectively what happened was there were a very limited number of people who had the relevant training, and they were effectively instructed, if you like, at the level of the school. Basically, they were answerable to the school. They weren't employed by the local authority, and in essence, as I indicated, the argument was that the way that potentially would operate in practice would be incompatible with section 42. So the essence of the challenge helpfully summarised at paragraph 2 of the judgment. I'm not going to go through the factual challenges that were made against the decision at first instance, because I think they're probably less helpful to us looking at things from a slightly more broader perspective. And I'll skip on to the slightly more systemic issues. Suffice to say, spoiler alert, the claim failed. And it failed sort of in essence on its facts, but I think this judgment does give some useful indicators of some more general points that are worthy of us bearing in mind. And I think potentially gives some indications of how a systemic challenge, sort of the levels that a systemic challenge would need to reach, certainly in terms of evidence, were it to be successful in a future case. Just for the benefit of anybody who is less familiar with this area of law, the judgment starting at paragraph 8 sets out a really helpful summary of the overall legal framework that applies under the Children and Families Act in relation to special educational needs provision, and sets out the process effectively from the duty to assess through to the necessity of a plan and then issuing a plan. And then once a plan has been issued, of course, that the provision must then be provided. And it's quite important to note, as the judgment does quite early on, and as Grania was touching on earlier, of course, that the nature of the Section 42 duty is mandatory. There's no duty of best endeavours or any defence of that nature. Once the provision has been identified, it must be provided for. And the reason that that's important in this case is because one of the points that arises is that it was said that because of the approach that was taken to the arguments around Section 42 and the way that the claim was rejected at first instance, there was a suggestion that it indicated that Mr. Justice Swift had failed to appreciate the mandatory nature of Section 42. So in essence, what happened was that on the evidence, there were some concerns about delay and the potential for delay in provision of the special needs, particularly in this case, and it was accepted that ZK was an example of many pupils in her position, insofar as she had a very high level of need, and it was a very particular level of need, which meant that it wasn't always straightforward to be able to identify people with the appropriate qualifications. And of course, where those people couldn't be identified, people would have to be trained up before they could then provide the support that was necessary. And there were concerns about the risk that would create delay in terms of a pupil having access to the provision that they require and therefore accessing the curriculum. And it's important to note in this case that ZK was educated in a mainstream school, and so she had the benefit of provision from teaching assistants and so on, who came into her mainstream school. So we skip all the way through the judgment to get to the first issue, which is effectively the first ground of challenge, and there were three, was effectively that because of the potential for delay and because the local authority was not responsible for employing the relevant people to provide the support, that the system, having a decentralized system in this way, was inherently incompatible with the mandatory nature of the duty. And for that reason, it was argued in the Court of Appeal that the rejection of the claim was either irrational or unreasonable. And so the Court of Appeal was invited to allow it. The Court of Appeal declined to do so. And in essence, what it said was that the premise of the challenge was that all provision effectively had to be by way of sort of employment at central level, central local authority level, because of course the Section 42 42 duty applies to the local authority as opposed to the school. But the court said that that was unrealistic. And in fact, whilst the claimant had relied on, amongst other features, the high level of need and the relatively perhaps unusual needs for support, those were actually arguments that went against the suggestion that provision had to be centralised in the way that was proposed, because effectively what it would have meant was that the local authority would have to retain people without necessarily knowing whether or not their expertise would be required in any given academic year. And it was noted that in Redbridge, there had been a period for some 20 years where there hadn't been need of anybody with the level of Braille training that was called for in ZK's case. And effectively the court said that that premise was unrealistic, and for that reason it was the judge had been entitled to reject the claim. But one interesting question that arose in that part of the judgment is what's the test that you apply in determining whether or not something is inherently unlawful effectively. And the judgment, there is some differentiated use of language as to what the test is. And so there's a question about whether the test is the test an inherent likelihood of unreasonableness or an inherent risk of unfairness. And in essence, the court comes down to the view that there isn't much difference between those two formulations. And in fact, the claimant had accepted, or the claimant's counsel had accepted, that effectively, if you're asking the question whether there was an inherent risk of unlawfulness, that about covers all of your bases. And that's quite important, actually, because there is some dicta where it would appear courts have said that the test is whether there's an inherent risk of unfairness. And sometimes it's described in terms of something of a slightly different nature, but effectively it doesn't matter. The question is there a risk of inherent illegality? And the useful touchstone is whether or not the relevant scheme is capable of lawful application. And obviously that's a fact-sensitive question. And so there may well be situations in other cases where you can demonstrate that. And I think one of the central difficulties that the claimants in this case faced was that the evidence actually didn't support them, or at least the court didn't accept that the evidence supported them in the way that they had claimed. And it's useful, I think, just to refer to paragraph 63, and I'll just read out what the court says there, so far as it's relevant. And effectively the court said, as Mr. Justice Swift correctly held, the principle is an applicable standard whether the case is a systemic challenge or is a challenge to unfairness in the individual circumstances of a particular case. So in this case, the claim was very much a systemic challenge. So it's effectively section 42 was always going to be breached, whereas you would obviously have other cases where there's a challenge to the fairness of the decision-making based on the individual facts of individual cases. And the court, effectively clarifying what I referred to as some of the inconsistent use of language, said that what matters in a systemic challenge of this kind is the need to distinguish between an inherent failure in the system challenged and individual examples of fairness or unfairness which do not touch on that system's integrity, however difficult it might be in practice to distinguish between those two situations. So in other words, the fact that you may be able to identify an individual case or perhaps a collection of individual cases where things have gone wrong does not necessarily denote a systemic problem. And of course, public lawyers will be familiar with similar dicta in terms of systemic challenges in convention cases. So that was effectively the issue in relation to section 42. The second ground of challenge was that because of the issues about delay and the issues that I've already flagged, it amounted to disability discrimination. And the claim for disability discrimination was brought both under the Equality Act and Article 14, read with Article 8, and the second protocol in relation to access to education. And effectively, the court said, well, doesn't really matter whether, and I should just clarify that the Equality Act claim, it was said that effectively the local authority, by operating the decentralised scheme in the way that it did, had failed in its duty to make reasonable adjustments. And the court said that the framework of analysis is effectively the same, whether you're looking at it through the lens of the Equality Act or the Human Rights Act, but that the claimant, and the judge at first instance was entitled to find this, that the claimant didn't get past the first hurdle of showing substantial disadvantage. And so it had been argued that the way that the scheme operated meant that children in mainstream schools with a high level of special educational needs, such as ZK had, were at a substantial disadvantage by comparison either to pupils with special educational needs at a lower level or pupils with no special educational needs or disability at all. And in fact, the court said on the evidence that there was no evidence of substantial disadvantage in the way that had been contended for. And so it had to follow from that the disability discrimination challenge also failed. And the last ground was a challenge in relation to the public sector equality duty. So the argument was that in operating Section 42 in this way, the local authority had failed to have due regard to its obligations under Section 149 of the Equality Act, to the need to eliminate discrimination and so forth. And what was interesting in this case is that the Court of Appeal again endorsed the approach of Mr. Justice Swift at first instance, which is effectively to say that the whole purpose of Section 42 was an exercise in attempting to eliminate differential outcomes for disabled pupils. And it made reference to a Supreme Court case that you might be familiar with, of MacDonald, which was a claim that was brought against the Royal Borough of Kensington, Chelsea, in relation to the provision of overnight care. And it was in that case in the Supreme Court where it was said that effectively, where you have a decision which is taken that is inherently looking at equalities issues, you don't necessarily have to have a separate explicit consideration of the Section 149 duty. And again, in this case, there was an attempt to distinguish that dicta as having arisen in the particular circumstances of an individual case and a systemic challenge such as this one. And the Court of Appeal said, no, effectively, that approach holds good whether you're talking about an individual challenge or a systemic challenge. So an interesting touchstone for the approach to be taken in relation to the public sector equality duty. Just a couple of brief observations of other aspects of the case that I think potentially might be interesting or at least worth noting. One of the complaints that the local authority made was that there was nothing in the case where the claimant had identified individual breaches of Section 42 in order to help illustrate what she said was a systemic failing. And the court said, actually, well, no, you don't need to do that because this is a systemic challenge. And in systemic challenge cases, the claimant is not obliged, doesn't have to advance breaches because, of course, the whole argument from the claimant's perspective is that the whole system doesn't work. And in fact, it's interesting to note, I think when you look at the judgment, that there was an attempt to get permission to advance late evidence, and that was rejected. Perhaps of more significance for our purposes is that the court really emphasises the importance of pre-planning. So one of the points that Mr. Justice Swift had made was that there was an expectation of pre-planning in order to avoid delays and so on. Now, in the course of discussing this issue, the claimant said that he appeared to effectively give an indication that where it wasn't always possible to do that, something less than absolute compliance would be acceptable. And the court said, no, that's a misreading of what Mr. Justice Swift has said. It's clear from reading the judgment that he understood the absolute nature of the Section 42 duty. But it seems to me that the emphasis placed on the importance of pre-planning taken together with the absolute nature of Section 42 might be helpful in some cases where you're dealing with a lack of proper engagement with the local authority, because it's quite clear that in order to eventually get to the right situation, that there is an expectation that the local authority and the relevant decision makers will engage proactively, particularly where you potentially have a child who will need support of a nature or level that is not readily available even in the context of special educational needs provision. So that's my very brief canter through the decision in ZK and Redbridge, bang on 6 o'clock. So there you go.
Yeah, well,
Stephen.
Thank you very much, Michael. As you can see, I've gone virtually to Santorini, or as a metaphor for how we might want to spend the rest of our evening. There are a number of questions, a couple of questions in the Q&A that people have already dealt with, I hope, and there's a bit of sort of discussion going on between various people within the chat and within the Q&A, discussing various, in a sense, answering each other's questions. So that a very useful use of an event such as this, that people can all put their own problems and solutions to each other without it necessarily, as it were, being a direct question on a specific issue to one of our speakers. Is there anything? I'm just looking at the Q&A. We've got. Yeah, I mean, Eleanor Wright raised an interesting observation on the Redbridge case about the decentralized provision and the relevance of academies, as opposed to some of the other, and the extent to which it's possible to consider judicial review against schools for failure to use best endeavours. Does anyone have anything to say about that?
I'll pick that up first, if that's right.
Yeah,
Stephen.
please do.
So it's probably worth saying as well that obviously the Redbridge case that I was talking about wasn't a COVID case, and you'll know that there were changes to the nature of some of the duties in relation to the provision of special educational needs during COVID, but those easements, as they're euphemistically described, aren't in place now. So I think the short answer is that if you have a situation where provision is not being made, then best endeavours isn't enough. It's section 42 and you're either complying or you're not. And if they're not, then send us some instructions and we'll find someone to draft a pat letter for you and get the grounds of claim on the go.
There's also, Michael, on a sort of related point, in the chat from Janet, could failing to provide PDA strategies and PDA trained staff be seen as disability discrimination? Is that one for you? I don't want to put anyone on the spot here, because of course these are questions that it's just that are just coming out of the world. But is that one that anybody?
I think it might be one for me, and I also think it could be in the right circumstances. I'm sort of trying to think through that as I'm answering, and I think you might be able to. You could potentially, I suppose, make arguments about whether or not it amounts to a failure of reasonable adjustments. Or at the public law level, whether it is indicative of a failure to have regard to the PSED if the training is being procured by a public authority. So it's possible, I think, unless somebody wants to disagree with me.
I don't think anyone's going to put that to say that they're going to disagree with you. There's also been a lot going around. So I'm just trying to filter through the Q&A. Do any of the panelists, is there anything that any of the speakers want to pick up out of the Q&A that you think either can be, you want to speak to or type while we're just going through this process?
I did notice there was an interesting comment that was made in response to Ollie's presentation about this idea that somehow the requirements for specificity are in practice less demanding in the context of special needs schools, because we can assume that the required provision will be made, and also that they're better placed to make changes that reflect a child's progression in perhaps a way that might not happen so readily in a mainstream school. I think somebody asked, again, it's a similar point. Somebody asked about, well, what do you do in the context of funding cuts and funding not being available satisfactorily even to special needs schools? And again, I think that in essence, that's not a satisfactory answer or a defence to a claim. If somebody has an entitlement, then it should be being made. And that, of course, is one of the reasons why I'm pretty sure it was a Redbridge case where something similar happened, and there was effectively a big issue about provision not being made, and effectively they tried to pray nay to the fact that central government had cut their funds. And if it wasn't Redbridge, I apologise, no defamatory imputations intended. But there are issues that necessarily follow from that, and I think it becomes just one of those really unhelpful fights that end up happening between the local authority and the parent as a consequence of what's happening at central government level. But I think from the pupil's perspective, from the family perspective, that's not an issue for the family. The question is that provision required? And if it is, it has to be made, and the money should be found from somewhere, which of course is why we also see more and more resistance to assessments and issuing plans in the first place, because local authorities understand that once those things are in place, they don't have very far to run.
They're hiding to nothing. There's been quite a lot of exchanges about specificity and issues arising out of that. I think most of that, well, Greg had a question in terms of specificity. Does the local authority need to write in the plan the level, type of qualifications of the professionals delivering a provision? Is there any case law or guidance on this point? Anybody want to deal with that one?
I can try.
Thanks,
I give a very unhelpful answer, Greg. Basically, I'm not aware of specific case law around the need for qualifications of professionals needed to be stated. My experience is that the tribunal will take a view based on the evidence, whether they actually need to have someone of that expertise. If so, then arguable that you can put it in and it's required. They might look at alternatives to qualifications, but and say X number of years of experience instead. You can certainly argue for certain qualifications to be included, but it would have to be, like with all specified provision, it would have to be based on evidence. And if you can use the other principles that are set out in Worcestershire to point in favour of specifying the qualifications. For example, you could say that, sorry, got a bit of a frog in my throat. So if you were looking at and a fly just going in front of me, which has completely lost my trail of thought actually. So yes, you can look at the other principles in Worcestershire as trying to in favour of your proposed provision. And one of the more important ones would be, I think just checking which point it was in Worcestershire. It's definitely one of them. Can't actually see it, which is a little bit embarrassing. But yeah, I'm pretty sure that in Worcestershire, there's that point that's made in Worcestershire about look at the nature of the provision and what the experts are saying. And if the experts are saying that certain amount of speech and language therapy of a particular specialist with a particular qualification, weight will be given by the tribunal to that. So I think it's all about coming together with the different principles that are in Worcestershire and say, actually, this is the level of specificity that isn't unreasonable. It is required for it to be enforceable. It's evidence-based, and the other side doesn't have a good reason not to do it. It's not overly restrictive, and it's not going to. And I think the key point that the tribunal is concerned about when dealing with issues of specificity is basically either backing the local authority into a corner where they can't actually meet it, or basically they'll only be suitable for a short period of time, because it will be matching a sort of need that will a level of granular need that might change throughout the course of the EHCP. So if you can avoid those issues and you've got evidence for the for the professional to have qualifications of some type, why not? But the tribunal might push back and say that's not necessary and that experience is all that is required.
Okay, thank you. Well, as
Sorry,
I said,
Stephen, unless Grania wants to come in on that, there was a couple of things I wanted to add on, if that's all right.
Yeah.
Grania, did you want to come in?
No, I was going to come in. I can see two more further questions in the last few minutes, but go ahead, Mike, on that point.
Great. So first of all, thanks to Maria, who's dropped a reference in the chat to the decision in BM and Oxfordshire County Council, which was a case where the absence of specificity about the training requirements of the learning and support assistant was an issue. And I agree with what Ollie said, and I've had issues where effectively I've had grumpy judges say to me, well, why would I want to specify that a person has to have, level 2 or level 1 or 4 years experience rather than 3 years? What happens if you end up with someone who's got 3.5 years and so on? And I think it does come down to having the right expert evidence and support. So I think if an expert is going to say that somebody needs particular qualifications, you really want them to address explicitly why that is, and if there's particular concern about proper support not being provided by somebody of less experience or less qualifications, get that spelt out pretty explicitly so that you can knock the tribunal over the head with it if you need to.
Okay, thank you. Grania, what were you going to say?
Well, no, just to echo what everybody's been saying about, I have had specification of qualifications in before, but only when all of the experts were very clear and very effective on it. No, I was going to come in on Mike's question. If a local authority mainstream school has stated they haven't provided provision in accordance with Section F because of funding reasons, but they also haven't applied for funding, is this a failure? And is it disability discrimination? I think it's probably both, but I don't know what other people do. But I think in order to avoid wasting time for the child and the back and forth which can entail around these failure to meet provision Section 42 cases, I do think there's quite good merit in pre-actioning quite quickly and bringing a Section 42 challenge against the local authority, because certainly, and we saw it in the BA case that we've discussed earlier, it can really drag on and there can be small steps of progress, but ultimately not provision being met. So I think I would probably think about bringing a Section 42 challenge against the local authority. It's ultimately their responsibility, it sounds like, in that particular setting.
Yes, I mean, and a general point is this is all an area in which kids' education is slipping by with whatever problem or whatever complaint or criticism needs to be addressed. So it is, in fact, incumbent on everybody working in this area to have an eye on the clock and to do it promptly, not just for sort of litigation reasons, but because ultimately, both the longer it goes on and the further the child gets through the education system, the less utility whatever it is you were hoping to remedy will have. So, it's all the speakers have sort of emphasised the sort of need for promptness, but it is a particular thing in this area, isn't it? I'm just there's a few more things in the Q&A. I'm just wondering to what extent it's helpful. Perhaps if anybody wants to, we can harvest the Q&A and people can answer those in put notes on it when the video is sent out to the delegates and so on, if anybody wants to do that. So unless there's anything that's particularly pressing or vital to raise at this point, I was going to bring this to an end, but Michael's got his hand up. There is something pressing and important.
There is, and it's a question I've just picked up from, I think, Paul in the Q&A. And the question is, does the tribunal have any remit with regard to the quantification and specification if the local authority expert evidence is very poor and families can't afford expert reports, I think that I was really keen to address that, because I think it raises a really important issue, particularly given that so many people are having to self-represent in the tribunal. I think it's going to be difficult, because on the one hand, you can say, well, the tribunal has its own inherent expertise, and you could potentially invite them to make some kind of assessment based on that. But you're also likely, I think, to get resistance on that, because they're going to say you need evidence based on the individual in this case. So I think if you've got a situation where the local authority evidence is very poor, and you're concerned that what you're going to end up with, or what the child will end up with, is something that's inadequate, then on balance, the best thing to do might be to invite the tribunal to adjourn so that proper evidence can be obtained.
Yeah, just on that, James in the chat took the words out of my mouth. Get the LEA's witness to attend and then push them, and the tribunal should be pushing them, because if they produced a rubbish report, which is vague and includes unenforceable provision, then the tribunal should really be putting them on the spot and saying, look, when you say opportunities, what do you mean? When you say some, how many hours? And it's really unfortunate that there's legal aid is out of scope and there's so many barriers to representation in tribunal. But I guess if you are advising a parent about specification and quantification, you really want to be give them the key principles in Worcestershire, and also let them know that the tribunal should be pushing experts on the other side to sort of do better and specify.
Taking us through now to the virtual refreshments that Garden Court has organised following this event. We've all been very much helped by the three excellent talks that we've had, and important cases both in the specifics of education law and more generally. And thank you very much for coming along to this event.